Welcome to Ask the Experts radio show, proudly sponsored by board-certified family law attorney Tina Lewert of Lewert Law, LLC. Sit back for the next half hour as host Steve-O interviews top experts in the fields of legal, health, financial, and home improvement. Steve-O offers such educational topics as community association law, family law, chiropractic care, employment law, healthcare law, and public insurance adjusting. Interviews by top experts in their field. And now, here's your host, Steve-O.
Hey, welcome. Good evening. You have the Ask the Expert show. We're with you every Thursday from 6 to 7 for your drive time. God, I'm sounding like an FM disc jockey. Ooh, that's not me. I got to tell you, I woke up this morning and went, we still have one more day to the weekend, and I realized today's Thursday. It's the first Thursday of the month, and that means K. Bender Rimbaum, our association law. It is, I hope my other experts don't hear me say this, but it is, for the last 4 years, K. Bender Rimbaum is like my favorite show, and I guess it is too. Our phones are already ringing off the hook already, and we haven't even got started. Welcome, Robert.
Hello, Steve. Hello, Steve-O, and everybody out there.
How you doing?
I'm doing well, and you?
I got to tell you, he just told me that his grandson's in from New York. Why does he want to live there, Robert? I don't understand. But Robert gives up an hour once a month with his busy schedule, and he's out there educating you, whether you're a board member, a property manager, or you live in a community. We have got some of the greatest questions tonight. Our boards are already full already, but if you'd like to call in, actually we have one line still available. We're at 888-565-1470. If you have a question about your association, we've got the finest attorney in Florida. So, see, I can see him. I don't know if you can or not. We do video this show also because we're on Facebook, Twitter, and Instagram. I'm so glad we have you, Robert. You're like my favorite show of all my shows.
Thank you, Steve. I'm happy to be here.
Well, I think people like the way you explain things. You don't talk over people's heads, and you are really so kind to everybody. That doesn't happen in all my cities. But let's first start off, and everybody, I've got, as you called in, we're going to get to you, but I want Robert to tell everybody about the firm because we have new listeners every week.
Well, K. Bender Rimbaum, as you say, is a law firm in Pompano Beach, Florida, that specializes in the area of community association representation. We also have offices in Palm Beach Gardens and Tampa. And we're covering most of the state of Florida from these locations, providing all of the day-to-day needs of community associations for their legal needs, whether it be reviewing documents, providing advice as to provisions in their documents, what rights and limitations a board may have, dealing with covenant violations, unpaid assessments, contract negotiation, dealing with defects in construction, litigation of all types and magnitudes for associations as they need it across the board. So anything association related from the law, that's what we do.
Well, what we do on this show is we have listeners who call in, and we have people who text me or email me throughout the month for the show. And we got to get to the phones, Robert, because we got a lot of people on hold. So we're going to go to Joe first in North Palm Beach. Good evening, Joe.
Evening. Can you hear me okay?
Can you hear?
Yes.
Okay? Yes.
Yes, I can hear you. Can you hear me?
Yes, sir.
Okay. I have two questions for you. Our board is sluggish on the ballot and the reserve funding. We're just getting around to it now. And I'm concerned with the ballots that they had sent out, that these are not legitimate ballots because they request on the actual ballot form themselves the unit number and the unit number of the unit owner's signature. Is this a valid ballot, or should that be an anonymous thing?
Well, if you're doing it through the mail, is this in conjunction with a meeting, or is it an attempt for a written consent to the question that's being posed?
No, it's a scheduled meeting for 2 weeks from now, and these are the ballots that were mailed out to all of the unit owners. They came with a separate envelope, which is to be handed in or mailed back, which gives the unit number on the outside envelope. But the inside is, you have to put your unit number and sign your name on the actual ballot that you are submitting.
Well, that doesn't sound correct. Typically, you would do that for a proxy, and a proxy form is handled differently than a ballot. And in a proxy form, you do have to put your name and your unit number and sign it, so they know that it's from you. But in a ballot that's being done as you would for the election of directors, then you only are supposed to sign the outside of the envelope. So it sounds like they're doing things a little bit different. Now, requiring you to sign it when you send it in does not violate anything under the law. There's no prohibition in the law that says that the board can't ask you to sign on a ballot before you send it in, and then you have the choice as the voting unit owner to sign it and send it or not. And if you choose to not, you should be able to attend the meeting and have your anonymous vote taken the night of the meeting.
I see. Because I had thought that all voting had to be at an anonymous ballot.
Well, if you're voting by proxy, then it wouldn't be anonymous. If it's a absentee ballot of sorts, then there has to be a way to identify who it's coming from and validate the ballot that's been submitted. Also, there has to be authority in your governing documents to allow you to do it that way. So there are open questions that would need to be looked at before a complete answer can be given to you on that.
Yeah, in other words, if these ballots are to be mailed in or handed in person at the meeting, is that still considered a proxy ballot?
Well, to be a proxy, there are specific items that have to be contained on the form itself to qualify. It has to have the name of the association, the date, time, and place of the meeting, the issues that you're voting, yes or no, and a place for you to sign. Or if you want to have a substitution, you also have to have a place to name a proxy holder. And then a substitution at the bottom is optional if you want to give the proxy holder the ability to have somebody else vote the proxy in their place. So it sounds like your board may be mixing things together.
Okay. The second and final question that I have for you, can the board members eliminate a board member?
Now, when you say eliminate, how do you mean?
Get rid of, discharge a
off
board
the board?
Yeah.
Generally, if you're going to remove a board member from the board, that's required a recall with a vote of the unit owners. If your governing documents provide for a mechanism for removal of a board member by other board members, there are possible ways to do it, but it would generally be in the form of, let's say, a board member misses 3 meetings without excuse, then that would be a deemed resignation, and the board can identify what's excused or not. So in that way, the board can remove a director. But generally speaking, it does require a vote of the unit owners to remove a board member. The board can remove an officer from the board, but there's still going to be a board member.
Okay, let's go to the next caller.
Okay, thank you.
Thank you so
Thank
much.
you.
Let's go to Lynette in Stewart.
Hi, good afternoon.
Hi, Lynette.
My question is, thank you. My question is regarding materials alterations of it's a condominium. So the membership was asked to vote on a material alteration to change the concrete tiles from to standing seam metal roof. And now they want to propose to change it instead of standing seam metal roof to use 5B crimp. Is that something that would require a membership vote again in order to do so?
If the membership were presented with a proposal to change the material of the roof from the tile to the metal, and now they want to use something other than metal, that's going to take another vote of the unit owners. The vote wasn't just to change the material that's put on the roof, it was specific as to what type to put.
I mean, it is metal, but it's standing seam. That's what it was presented. And now they wanted to change it to 5B crimp, which is another type of metal roof.
It's going to depend on the presentation that was made by the board to the owners and what specifically was voted on, whether or not the change. What is considered a material alteration can be very specific, and certainly the Division of Condominium looks at it very narrowly, and the courts a little less so, but still the definition that has evolved through the years through the courts has been a palpable change in what material is being used, palpable being the word the court used, and that's a very specific type of identification. So from what you've described, it sounds to me like you're going to need another vote of the owners to do that other change that they're now proposing.
Okay. I really appreciate your help.
Thank
you very much.
All right, thanks for listening.
We have a line open at 888-565-1470. Before we go to break, let's get Barry in from Miami. That's a familiar name, isn't it?
Well, there's a few Barrys out there.
Robert, fine. How are you? My question's a murky one. I'll make it quick, but it's a hard question. I'll tell you that. Our board's management agreement provides that our board will release the property manager from any claims. We waive any claims against the property manager for gross negligence. Now, I know the law says that a board cannot indemnify a property manager for gross negligence, but that's not the way it's drafted. We waive any claims the board waives any claims against the property manager for gross negligence. Do you think that would fly if there ever was a case where there was gross negligence and the board wanted to bring a cause of action against the property manager?
Well, since it's in your contract and is expressed as such, and it's considered an arm's length transaction with equal opportunity for both parties to have advice of counsel in reaching the decision, in all likelihood, a court would view that as an agreement made by the association to waive any such claim and be held to it. If there are facts and circumstances that can be brought to the court's attention that the transaction was not at arm's length, that there may have been something else going on behind the scenes that might provide
totally arm's length. Yeah.
Totally arm's length.
Totally
It's not a good provision, and it's not one we would advise our clients to allow to stay in the agreement, but the board can make that decision on its own.
Okay. Thank you very much. I appreciate it.
All right. Let's hope there isn't any gross negligence there.
Hey, we're gonna. I want to ask Robert, because K. Bender Rimbaum does events and classes every month, and you've got your
No, we
schedule.
have a lot this month.
And I just want
Lot
to
to tell
say,
you.
Jeff and Patty and Michael, hold on. We're coming to you right after we do this with Robert. What does the schedule look like this month?
You want to hear it?
We're ready.
Okay. Starting next Tuesday, we've got a double header going on. Not in the same place, though. We have a live presentation at 9:30 until noon at the Palm Beach Marriott in Singer Island, which is hosted by the CAI Gulf Coast chapter. The topic: condo safety and Florida legislation. What does this mean for me? Panelists will include Michael Bender and Travis Moore, who is a lobbyist in Tallahassee for Community Association Institute. That's at 9:30 a.m. next Tuesday at the Palm Beach Marriott. On April the 12th, also the second half of the doubleheader, noon to 1 p.m. is a Zoom covenant enforcement for HOAs and condominiums. Will be presented by Andrew Black from the Pompano Beach office. There is one CEU of a continuing education credit. That's at noon on Tuesday the 12th. On Thursday the 14th, another Zoom hosted by CAI in Florida with Michael Bender and Travis Moore, Community Association Legislative Update with the Florida Legislative Alliance, 12:30 to 1:30 on Thursday, April 14th. On April 19th, there will be the Broward Expo at the Signature Grand from 9 to 4:45, 9 a.m. to 4:45. We have a booth there, and we'll have a course we're teaching on guest restrictions at 9:30, and a 2022 legal update at 2:30. To register, it's Broward Condo HOA Expo.com, or go to our website, you'll find it there. And then on April 21st, we have a Tampa Bay Condo HOA Expo from 9 a.m. to 4:30 at the Tampa Convention Center. For all our Tampa listeners, we're going to be teaching the 2022 legal update at 2:30 there as well. And you register at Tampa Bay Condo HOA Expo.com. You'll find that on our website as well. For both of those events, those are in person. On April the 20th, a Zoom 40, 50-year recertification at 12 noon to 1 p.m. Hosted by the Castle Group. Panelists will include Michael Bender and Jeffrey Runbaum. That's on Wednesday, April 20th, 12 noon to 1 p.m. Then on Wednesday, April 27th, 12 noon to 2 p.m., we have Condo and HOA Board Member Certification. It's a combined Board Member Certification. So that's why it's 2 hours. It's on Zoom, hosted by Real Manage. And Lisa McGill from the Pompano Beach office will be teaching. This is certification only for board members. There is no continuing education for CAMs. Then on Thursday, April 28th at 12 noon to 1 p.m., Jumping into the Present, Why Updating Your Documents is Critically Important. That will be hosted by Campbell Property Management, and the instructor will be Emily Gannon from the Pompano Beach office. There is one CEU of continuing education in that course as well. So that's what we have going on in the month of April.
That is the busiest
All of this
month.
can be found at kbrlegal.com. Look at event-calendar, or just click on the calendar and you'll find the event. Click on that and it'll get you registered so you can get your Zoom information or information for the live events as well.
Hey, Robert,
Busy month.
we got two people who've been waiting since we opened the show up. Let's go to
Let's
Jeff
do
in
it.
Coconut Creek. Hi, Jeff.
Hi, good evening, and thank you for taking my call and questions. I have two that are interrelated. First of all, I am an owner with an HOA falling under Statute 720. Our board, as well as the entry signage, states that we are a 55 and older community. This is not reflected anywhere within our governing documents whatsoever. They have a line in our rules and regulations that changes constantly that says, quote, we're self-certified as housing for older persons under Florida law. But they selectively use this rule to deny ownership. Isn't this age discrimination, Robert? When brought up at a board of directors meeting, I was told that there was nothing in our documents. They just enforced this rule. And then the second part of this question that goes hand in hand, I said to them, well, you could be sued for age discrimination. They said they're not worried because they're covered by the association's director and officer insurance policy. Does a D&O policy generally protect them from such illegal positioning?
Well, Jeff, first question first is how the association can qualify, the community can qualify as housing for older persons. And one of the basic requirements is that there has to be provisions in your declaration of covenants that identify the restriction. The purpose of housing for older persons is to allow you to legally discriminate against a protected class, families with children under the age of 18. So in order to qualify, the first item you have to have is a provision in your governing documents specifically, not your rules, your covenants, that identifies the restriction and the requirement that each of the properties have a permanent resident over the age of 55 years and that there be no children permanently occupying under the age of 18, and allowing for some visitation, with the understanding that you have a 20% allowance that you can have for some of the properties that would not necessarily have to have somebody 55 or older living within it. So not qualifying on the basic item means that any attempt to keep out children will be discrimination based on familial status. Age discrimination can also come into play. Some counties have it, some do not. I believe Broward is one that does. Unless you're qualified as housing for older persons, you cannot limit between the ages of 18 and 55 as to the occupancy. So only if you're enforcing the familial
census also every couple of years under the HOPA guidelines. They never do that.
They don't do a census either, so you have that as another nail in the coffin. So the fact that the board is doing this, if they're doing it with knowledge that they don't qualify, there is the possibility that your officer and director insurance will not cover them, because that would rise to the level of intentional willful misconduct as opposed to mere negligence. And as willful, intentional violations of existing law, your insurance carrier may choose to deny coverage. Now, they may provide attorney defense, but they may not provide for any damages that you may lose if it goes to a litigation setting. So it sounds like your community is putting itself at risk rather significantly.
Okay. You answered my question quite well. Thank you so very, very much for taking my call.
Thanks for waiting, Jeff.
Yeah, thanks for listening.
Yep.
We have a line open at 888-565-1470, 888-565-1470. Let's go to Patty at Oakland Park. Hi, Patty.
Hi, Robert.
Hello, Patty.
Hi, it's Patty from Middle River. Long time no see. I have a unit owner that reported a leak on January 12th, stating at that time that it resulted in the need to replace both bathrooms and a master closet. Also stating that her contractor, she already had a contractor at that time, and that there still might be active leaks because of water, but she says her water had been off for almost a month already. So that meaning that she hasn't been living there for a month while there's a water issue. Now, we addressed this letter that day. She said she had previously notified us, but there's no record of that notification. On 12/2/18, she signed a remediation contract. On 3/24, she submitted us a bill for replacement of drywall, and on 4/1, she gave us a bill for the tear out of all the drywall. Now, since she had a remediation company, they tore out anything and everything. Isn't there a law that says we have to be notified within 2 weeks of any notification of any leak issues?
There isn't a specific law that identifies a time frame that you need to be notified, but you do need to be notified in a timely fashion of the type of issue that has occurred. So if the owner didn't tell you, and the chances are that the owner wasn't in occupancy, as you indicated, that would be some form of contributory negligence on that owner's part. From what they're asking you to cover, it sounds like it's limited, as you say, just to the drywall, which is a part of an association obligation under an insurance claim if it's an insurable event. If it's a maintenance-related issue, that changes things. Let's say that whatever the leak was caused by wasn't a sudden thing, it was ongoing over time. Insurance companies consider that often to be a maintenance-related problem as opposed to an insured one and would deny coverage. In that instance, the association's drywall requirement is only the perimeter walls that go around the unit, not the interior partition walls. It would probably make sense to submit the claim to your own carrier to see whether or not they're going to cover any or all of it for you, which might eliminate the need to get into any kind of a legal issue with the unit owner on it. But of course, you have the option to deny it and fight it, but that could run you more money than it would cost to fix it.
Does that help?
Exactly. That's my concern, I guess.
What's
So
that?
the leak is within the walls. So if there's a
Have
pipe
you,
in a wall
have
that's
you
leaking,
identified the source of the, Patty, have you identified the source of the leak and made sure it's been resolved? And was it in the common element?
yes.
Okay. Well, that doesn't make the association negligent, the fact that a leak occurred. So your obligation would be to identify the source and fix it. The association is also responsible for certain drywall that surrounds the unit as also being part of the common element. So unless the owner was negligent, or you can claim their lack of notice to you was a significant contributing factor that increased the amount of damage, and you can consider going after it in that approach, but it is speculative and one that could take a lot of expense to prove.
Yeah. I guess because she states that the water had been off for a month, that previous to this letter, previous to her notifying us, a month in a unit with moisture and not living there probably means the air conditioning wasn't running also. So yes, there was evidence of mold throughout the unit on clothing, personal items, etc.
And did they contain it within the unit, make sure there was nothing in the common elements or other units?
Okay, and I guess that's it. On another question, do you know what the square footage requirement is for the 40-year inspection? Our buildings are 2 stories tall, but what is the square footage?
Off the top of my head, I could not tell you, but I think that you do qualify for it anyway. My building is 1 story, and we're qualified. So although ours is a commercial building, we'd have to confirm that for you. So if you want to check with us in the office tomorrow, be happy to fill in that blank for you.
Okie dokie.
Thank you,
Thanks,
Nancy.
Oliver.
Patty. Thank you, Patty.
Okay, listen, Rita in Boca and Nancy in Miramar, we're coming right back to you. We got to go to a break. Robert, give everybody your phone number and your website address.
You can reach us at 800-974-0680 or kbrlegal.com or email info@kbrlegal.com.
Okay, we're going to go to break. We come back, we have more with the K. Bender Rimbaum, might as well call it K. Bender Rimbaum Show, with attorney, board certified, Robert. Robert, don't you go away. We got our boards are full. We'll be right back.
I'm here.
K. Bender Rembaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida, with offices in Pompano Beach, Palm Beach Gardens, Tampa, as well as in Miami-Dade by appointment. Several K. Bender Rembaum attorneys are board-certified specialists in condominium and plan development law, and they assist clients with all matters of community association legal issues while keeping them up to date on new developments affecting their associations. K. Bender Rembaum is also a well-known provider of free legal education, which often includes CE credit for managers and state certifications for board members. Contact K. Bender Rembaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or just write to them via email at info@kbrlegal.com.
We are back now with more of the Ask the Experts radio show, proudly sponsored by board-certified family law attorney Tina Lewert of Lewert Law LLC, covering South Florida.
And we're back. This is the Ask the Expert show. You know, I just thinking, I've been doing the show with the producer, Freddie Santori. And I got to tell you, we get so many calls for this show. And Freddie came up with this great concept that right in front of me, I've got a laptop. I can see everybody's calling, where they're from, and I actually look like I know what I'm doing. It's so much easier than we used to have.
Nice.
I know. I love it. We do have a line open at 888-565-1470. We have this is the K. Bender Rimbaum Hour, the first Thursday of the month from 6 to 7, and every month we talk about HOA and condo law. Let's go to Rita in Boca. Good evening, Rita, and thanks for waiting.
I have a question about the president, a newly elected president of our board, who is submitting a proposal to take over the maintenance project, the contract for maintenance of the cleaning and maintenance of the association. Is that legal?
The president owns a company that is going to take over, is asking to be considered to take over the maintenance for the building?
The president of the association.
That's what you're saying. Is he going to do it himself or with a company?
Well, it's his company. He'll probably work on it, too, because he does maintenance.
Well, under
regular
Florida
job.
statute, as it applies in condominiums, in order for the president to have a contract with the association, he has to follow specific guidance that the statute lays out with notice to the board of his connection to the company, and it would allow the owners the option to vote to cancel the contract at any point after that. It's a specific requirement within Chapter 718 for a board member to have a direct contract with the association. It is technically a conflict of interest, but that alone doesn't disqualify it. If there is the appropriate notification to everybody.
My phone is making noise, so I couldn't hear everything you said.
I'm sorry, Rita?
You said that there was a change in the law recently, in the statute that allows this.
Not that recently, but there is provisions in 718 that will allow the association to have a contract with the president so long as there is the notification of the interests of the president and the new company. A supermajority of the board has to vote in favor of it, and the owners have the ability to cancel the contract after you're into it.
So yeah, I can't hear you that well, but what I think you said is that the board has to approve it first. Is that correct?
The board has to
It's not
approve
a
it
secret
first.
that it's his company. I mean, he's presenting it as his company.
I think she wants to know if it's a
Okay,
conflict of interest.
it
Well,
is
it
a
is a
conflict of
conflict of
interest,
interest, but is
but it's
it
still
illegal?
possible to be done legally.
It's not legal, or it is legal?
It
It
is.
is legal if we follow the right procedure.
Okay, I don't know what the right procedure is because he's notified us that it is his company.
And there has to be reflected in the minutes of the meeting that they're considering it, that relationship. And it takes a supermajority of the board, not just the majority. So you need at least, how many board members do you have?
Board members, we have 5.
So you need at least 4 of the 5, and that individual can't vote. And he has to
Right.
abstain from voting because of his personal interest.
So it would have to be 3.
No, the other 4 have to vote yes.
All 4?
All 4.
Okay, well, that's not going to happen. So we don't have to worry about that.
All right.
I think there was something else. What the heck else was that? I think that's about all.
Okay, Rita. Thank you
All
for
right, Rita,
calling.
thanks for listening.
Right now.
Call in anytime.
We have a
Thank you
line
very
open
much.
Good
at
luck with that.
we have a line open at 888-565-1470. If you have a question for Robert, let's go to Nancy in Miramar. Hi, Nancy.
Hi, Robert.
Hello, Nancy.
Thank you for taking my call. My question was that in the documents, in the condominium documents, it's not stated that an owner needs to be on a rental list, or it doesn't say anything about having to reside at the unit for 1 year. But the board has made like some kind of law where they are only allowing 33 units to rent at one time. And as the new owners come in, they explain to them that they need to be on a rental list and that they need to be, owning the unit for 1 year before they can rent. Is this legal? Can they do this?
As you have described it, no. It has to be something in your condominium document, your declaration of condominium, that contains the limitation on leasing for the first year and allows for the board to create the policies of the rental list and the limitation on how many units can be rented. That all has to be in the declaration of condominium before the board can do that. If they're doing it by board rule alone, then they are not doing it legally correct.
Legally, okay. So if I was to write to the ombudsman, do you think they might send them a letter or something saying that they need to stop doing this? Or
No, that's not a function of the ombudsman, unfortunately. The ombudsman's there to
It's
educate
not?
people. They won't write letters on behalf of owners that think there's a violation going on. You would have to file for either pre-suit mediation or a petition for arbitration with the Division of Condominium. I don't think what you've described would be something that the enforcement section of the division would address on its own. It might be faster for you if you hired your own attorney, or you or other unit owners that want to pool your resources, hire an attorney to write to the board to tell them what they're doing wrong and give them an opportunity to do it right before you get involved in bringing legal action against the association.
Okay, so any individual owner can go ahead and do that, right?
Yes.
Okay, perfect. Thank you. That was my question. Thank you for
Listening,
your
Nancy.
time.
Thank you,
Okay.
Nancy. We have a line open at 888-565-1470. If you have an HOA or a condo question for Robert K. You know what? We got a lot of mail about renters this time. And one of them that we kind of chose was, how come renters have no rights when it comes to attending a board meeting, Robert?
Well, board meetings by statute are open to unit owners, and a renter is not a unit owner, so they don't qualify. The board has the power to invite anyone they want to attend their meeting. So if the board wants to open it up and allow renters to attend, the board can do that. But if the board chooses to limit attendance to just unit owners, the board can do that as well.
This is from Bonnie in Boynton. She says, "Hi, Robert. Love your show. You know, and have you ever noticed how they all say hi to you? They don't ever say hi to me. That's okay. That's fine. My feelings don't get hurt.
They mean to include you in that.
Yeah,
for
okay.
Sure.
Anyway, they want to know, what are your feelings on paying board members so that we can attract better candidates?"
Well, in order to pay board members, there has to be a specific authorization to do so in your governing documents, and that would likely take a vote of the unit owners to do that. Another alternative is the owners can vote to approve it, but you need to have some authority to do that. The board cannot just start paying people without having the documentary authority in place to allow that to happen. I don't know that it's ever worked anywhere to pay individuals and think you're getting better people by paying. Um, Ideally, you want people who are vested in what's going on in their community, which volunteer owners tend to be, and whether or not they, again, it's a community by community thing. So
Okay.
it's not something you can do without the documentary authority to do so.
Let's go to Herb in Tamarack. Good evening, Herb.
Good evening, Bob.
See?
I'm a former president of a condominium in Tamarack consisting of 9 buildings, 9 associations, and 1 overall neighborhood association. I have a problem. A tree fell by our building across the roadway in an emergency. I had to remove the tree. My building paid for the removal and cutting up and so forth. Then I carefully was reviewing the documents and bylaws for the neighborhood, and I found out that according to what I've read in the documents, the common areas fall under the responsibility of the neighborhood. Under the definition of common areas is the word green areas. So I am insisting that our board go after the neighborhood to recover some $2,700. Do I have a viable situation based upon what I presented?
Well, Herb, I can only tell you maybe, because it really is going to depend on the specifics in the documents and the specifics of where the tree fell, and if it fell into the condominium or it was solely within the boundaries of what is the neighborhood common areas. If it's within the common elements of the condominium, which most of these communities that you've described have common element boundaries for the condominium, and then there are perimeter type areas that the master overall would be in charge of. And also depending on what happened to the tree, how it fell, why it fell, how it was maintained prior to. There's a lot of factors that go into ultimately deciding whether or not it's a viable claim against the master association. As you described it, it's a possibility, but I can't say for sure.
All right, so this is something that would have to be reviewed by an attorney.
I think so, yes.
Am I allowed to ask you if I turned over or sent papers into you, what would it cost for an evaluation and an opinion?
Well, that's not something I could address on the air here. We'd have to see some documentation before I can tell you what it might cost to ultimately review it all and give you an opinion. So that's something we'd have to do in the office.
Give him your phone number,
I
Robert.
could call you. I have your phone number, so
Okay,
I could
good.
call you at your office.
Yes, you can call the office, and it would need to be on behalf of the association, I presume, your condominium association.
Well, I'm no longer on the board, and the board is hesitant to go ahead and do anything. And I'm thinking of taking up the challenge on my own.
Well, that's laudable to you, but it might be more headache than it's worth in the long run.
Okay,
For you to bear
that
the
I will
cost of
understand.
an attorney review, which could be, several $100s into the thousands of dollars, that may not be worth your while.
Well, okay. Sometimes in life, principle is more important than dollars. All right,
Principles
I
can be
will
very
call your
expensive.
office. All right, thank you
Thank
very
you,
much.
Herb.
Appreciate the information.
Thanks for listening.
Oh, we've had so many great callers tonight. We have a line open. We still got about 8 minutes. 888-565.
Get them in while you can, folks.
1470. We got a question from about a president doesn't have to be a unit owner on a board. Is that true?
Well, the law in Florida as it currently stands is that board members and officers only need to be members or owners within the community if the articles of incorporation have that requirement, at least as for board members. Officers, you would look to the bylaws for that, but generally speaking, your articles of incorporation have to require membership, unit owner, in order to qualify for the board. If it's silent, then the answer would be no. Anybody could be on the board. The bylaws typically contain qualifications for the officers, the president, vice president, secretary, treasurer. Typically, the president, vice president might be required to be board member, secretary, and treasurer often are not. And they can be anybody. They don't have to be owners. Typically they are, and typically they are from other board members, but they would not have to be. So you look to your governing documents to get the specifics as to what the qualifications would be. We've had clients through the years that were run for many, many years by a tenant, and the tenant spent hundreds of hours a month working for the association in which that person was a renter. So it does happen.
I'm going through looking at all of our questions. Here's, since we just got off with Herb and Tamarack, here's Jackson in Tamarack. He lives in a condo. A lot of Tamarack. If the board has received numerous emails of violations and they don't do anything, does that void the director's insurance?
No. It shouldn't really come into play unless there is a claim made that involves the specific issue that they are otherwise documented to have ignored. So it really will depend on the situation. Director and officer insurance is to provide insurance coverage for negligence that the board may commit. Not gross negligence, or willful misconduct, but certainly if they're negligent on something, then their insurance should cover it.
We got an email from Phyllis in Boynton Beach, and she didn't really explain, but you've been doing this for so long, you'll probably know what she means. She said, Robert, what can we do if our board is in turmoil? I don't know what that means, but you probably do.
Well, that probably means that they're not getting along and they can't make decisions. They're evenly split and no decisions can be made, no actions can be taken, and therefore the association cannot operate. It's a difficult problem when that happens in a community because one method of resolution is by election, so you may have to wait until the next election, but then you have to have volunteers that are willing to participate. Another method of resolution is recall, which would allow the unit owners to remove the board members who can't seem to work together and replace them, or some of them, with those who can. So that's another method of resolving it. Beyond those two methods, unless you can sit them down and get them to work together somehow for the good of the community, it doesn't really leave too many other choices.
Yeah, I'm trying to look for some really simple questions because we only have a couple minutes. I kind of really know the answers, but who does the attorney work for, the unit owners or the board?
Well, actually, neither. The attorney works for the corporation, which is the association. The association acts through the board, so the board is the party that contacts the attorney and gives instructions. So it appears that the attorney is working for the board, but only because of the manner in which the structure of the corporation is established. That's how it works. The unit owners only generally get to vote on who's on the board, amendments to documents, whether or not to waive reserves, and any other specific item that's contained in your documents. And there could be a couple of other items, but generally it doesn't have anything to do with dealing with the association's attorney.
Well, we've come to an end of another show. What a show tonight. I mean, we had some... Yeah, amazing. Anyhow, give everybody your phone number and also your website that's got so much valuable information on there.
You can call us at 800-974-0680. Our website is kbrlegal.com. You can go and write us info@kbrlegal.com, or on the website there's a contact me item. You can fill out information and it'll come to us and we'll get back to you. Otherwise, we'll see you next month. Have a great April.
Hey, and thank Mrs. K for sharing us with you once a month. Thanks so much. And we'll.
Thank you for tuning in today to Ask the Experts, sponsored by board-certified family law attorney Tina Lewert of Lewert Law, LLC. Join host Steve-O again next Thursday for more interviews with the top experts in South Florida in the areas of legal, health, financial, and home improvement on Ask the Experts.